Good evening, everyone. I'm Charmaine, the host of today's seminar. On behalf of Hong Kong Policy Research Institute, I'd like to welcome and thank you all for joining. The topic of today's seminar is the Hong Kong SAR system under the One Country, Two Systems, in which our speaker will talk about the three branches of the Hong Kong SAR government, namely the executive, the legislature, and the judiciary. He will also talk about the rights and freedoms guaranteed by the Basic Law and the Hong Kong Bills of Rights, and the 5 Basic Law interpretations by the Standing Committee of the National People's Congress. These are all hot topics in today's Hong Kong, so I hope everyone would enjoy the seminar. Our speaker tonight is again Mr. C.M. Chan, head of the Center for the Rule of Law. He is also a distinguished practicing solicitor in Hong Kong, England, and Wales. So without further ado, let's get our seminar started. Please welcome Mr. Chan.
Thank you, Charmaine, and thank you everyone for attending tonight's seminar. Like Charmaine said, this is the second of the series 2 of the Basic Law Education. For those who did not attend the seminar last night, I give you a quick review what we talked about last night before I move on to today's topic. Yesterday, we spent some time talking about the history of Hong Kong, why we are here, the current system, the historic background, Hong Kong being historically part of China for the past 2,000, 3,000 years. And the nature of the 3 unequal treaties, which resulted from the Opium Wars between Great Britain and China in the 19th century. These 3 treaties were considered, quote, unequal, close quote, by China because they were signed as a result of a coercive force, basically after a defeat of a armed conflict between Great Britain and Imperial China. And as the result of the treaties, Hong Kong was ceded or leased to the Great Britain. And in 1997, Hong Kong's sovereignty was returned to China, or China resumed sovereignty over Hong Kong in 1997. So that we talked about all these background with the Sino-British Joint Declaration signed by Britain and China and registered under the United Nations. And then, of course, the Basic Law, which is the constitutional document for Hong Kong, passed by the National People's Congress of the People's Republic of China in 1990 and was put into effect on the 1st of July 1997 and becomes Hong Kong's important constitutional document. So that's what we talked about yesterday. So building on these basic concepts, so today we're going to talk about the chief executive and the executive authorities, the executive branch of Hong Kong, after the handover, the legislature, the judiciary. I'll touch on the rights, duties, and freedoms of Hong Kong people. And finally, an important topic, interpretations of the Basic Law. Executive authorities, or the executive branch of the government. Hong Kong, it's used to be a colony. It's sort of very typical British style colony with the governor representing the Queen in Hong Kong. And the last governor in Hong Kong was Chris Patten. He represented the Queen in Hong Kong. So basically he presided over the legislature and also the head of government. So this tradition sort of, to a certain extent, continued into 1997. Of course, with a lot of modifications under the Basic Law. After all, it's now a special administrative region under China, not a colony anymore. So I guess what I'm trying to say is Hong Kong's current structure is rather unique. It has some relic from a colonial style government. On the other hand, because of the Basic Law, the Basic Law introduced certain extent different elements borrowed from Western government. Then again, Hong Kong is not an independent country, not a sovereign country. It's part of China, which I explained yesterday, is a unitary country. So all this add together, making Hong Kong's political structure rather unique. So the first branch of the government is the executive branch. Let's look at the relevant provision under the Basic Law, Article 59. The government of Hong Kong shall be the executive authorities of Hong Kong Special Administrative Region, Hong Kong SAR in short. Under Article 64, the Hong Kong government shall implement laws passed by the council and already enforced. Remember we talked about yesterday when Hong Kong's sovereignty returned to China, all the laws previously enforced were maintained and continued into the new administration. Under Article 64, regular policy addresses to the council made by the chief executive. The chief executive shall also answer questions raised by the legislative council. Number 4, obtain approval from the council for taxation and public expenditure. So all in all, what this provision is trying to say, there's a check and balance. The Hong Kong government, being the executive branch, shall go to the parliament. In Hong Kong, we call it legislative council. That's what the slide is talking about, the council. Legislative council, our parliament, our local parliament, to explain, to be accountable to the elected members of the legislature. So in that sense, it's quite similar to the US Congress arrangement. Of course, Hong Kong, like I said, is not an independent country. There are a lot of difference, which I'll come back later. But from that angle, the executive branch is held to be accountable to the Legislative Council, at least to that extent. Or put it the other way, the legislature, the Legislative Council, the most important power is to approve the budget put forward by the executive. And the chief executive has a duty to answer questions. So this is an important starting off point. This is a picture of our current chief executive, Ms. Carrie Lam. Article 43 of the Basic Law, the chief executive shall be the head of Hong Kong SAR and shall represent the region. Article 44 talks about the eligibility, who can be the chief executive. Chinese citizen of not less than 40 years of age, a permanent resident with no right of abode in any foreign country, and has ordinarily resided in Hong Kong continuously for not less than 20 years. Again, these are quite common, I would say, in any other jurisdictions. Special requirements for some people to be the president or prime minister or the head of state of a country. The power of the chief executive, Article 48. Number 1, to lead the government, the Hong Kong government. Number 2, to be responsible for the implementation of this law, i.e. the Basic Law, and other laws which, in accordance with this law, apply in Hong Kong. So there is an obligation on the chief executive and his government to implement law, to uphold law. Number 3, to sign bills passed by the Legislative Council and to promulgate laws. This is quite similar again to the UK or US style government, whereby the president or the prime minister, or in the UK, the case, the monarch, the queen will endorse the law passed by the parliament. So similarly, the chief executive will put the law or promulgate the laws passed by the legislature. To sign the budget passed by Legislative Council, report the budgets and final accounts to the Central People's Government. So again, this is unique. Hong Kong is not a sovereign country. So after all, there is a central government above Hong Kong. Although Hong Kong is under a high degree of autonomy, there are still in some provisions that there are a reporting line, so to speak, from the Hong Kong chief executive to the central government in Beijing. Number 4, power of the chief executive to continue, to decide government policies, to issue executive orders, to nominate and to report to the central government for the appointment of principal officials. There are a number of important high-ranking officials within the government to be nominated by the chief executive, but to be appointed by the central government. This is important. So this is express power by the central government to make the appointment, not the chief executive. The chief executive only make the nomination. So these include the secretary, the chief secretary, the financial secretary, the secretary for justice, the commissioner of police, director of immigration, etc., etc. Those most important ones will be appointed by the central government. Number 6, important one as well, the chief executive of Hong Kong is also vested with the power to appoint and remove judges. So chief executive appoint all the judges in Hong Kong. Number 7, to appoint and remove holders of public office in accordance with legal procedures. Number 8, to implement directives issued by the central government. So this is interesting when you look at this express power or obligation of the chief executive. Directives issued by the central government. So this should be looked carefully with the wider concept of high degree of autonomy. Of course, we talked about Hong Kong, basically Hong Kong people governing Hong Kong. This is the concept. However, if you look at the basic law, there are a number of places that put in place in the constitutional document that the Beijing central government has a say in many little things. This is one of the examples. Number 9, to conduct on behalf of Hong Kong government external affairs authorized by the central authorities. Again, I mentioned yesterday that Hong Kong is so unique that even though it's part of China, it still maintains certain international obligations and relations with international bodies like the World Trade Organization. Hong Kong is a standalone member. Hong Kong is a standalone member. Hong Kong China, I should say the official name should be Hong Kong, China, can be a standalone member in the Olympic Games, for example, in the World Cup Games. The important part should be authorized by the central authorities. So these are all possible because of the authorization from central government. Number 10, to approve the introduction of motions regarding revenues and expenditure to the Legislative Council. 11, to decide in the light of security and public interest whether government officials or other personnel in charge of government affairs should testify or give evidence before Legislative Council or committees. I explained a bit earlier, which I'll talk a little bit more about the legislature. The executive branch is obliged to go to the legislature to explain government policies. But 11 actually has a caveat here. The chief executive has a power to decide which or whether a government officials should testify or give evidence. Number 12, to pardon convicted criminal offenses. Again, this is not unusual. We've heard that quite lately in the US. The president was actively considering making pardons in his last day of administration. Same power to be given to the Hong Kong Chief Executive. Number 13, to handle petitions and complaints. So all in all, the power, you can see that is very, very extensive, a very powerful position of the Chief Executive. On the other hand, it still has some, the central government has a certain role to play in terms of Hong Kong's administration. Article 43, accountability. The Chief Executive shall be accountable to the central government and the Hong Kong Special Administrative Region in accordance with the provisions of this law, the Basic Law. So this sort of summarizes the unique position or obligations of the Chief Executive. It's a bridge between the central government and the residents of Hong Kong. Some commentaries in Hong Kong always said that, oh, the Hong Kong Chief Executive has two bosses. One is Beijing, one is Hong Kong citizens. It's not untrue in that sense, that because Article 43 expressly say that it's accountable to the central government and also to Hong Kong. CE election, Chief Executive election. This is a important topic, of course, and a controversial one, especially in the past 5-6 years. The Chief Executive shall be elected by election or through consultations held locally and be appointed by the Central People's Government. This is in the Basic Law. Very important. I think it's Article 45. You didn't say it here, right? It's Article 45. So important that, number one, it can be selected by election. The keyword is or. In fact, the Basic Law does not say that there has to be an election. In a way, the Chief Executive can actually be chosen by consultations and be appointed by the central government. This is another key element here. Chief Executive power derived from the central government. So even after election or after consultation, there is still a procedure of appointment by the central government. Okay, this is the Basic Law. This is our constitutional arrangement for Chief Executive. Do remember this when we talk further about reforming the way we choose our Chief Executive. Next paragraph, we talked about the method for selecting the Chief Executive. The Basic Law actually said that it should be done with the principle of gradual and orderly progress. The ultimate aim is for the Chief Executive to be chosen by universal suffrage upon nomination by a broadly representative nominating committee. This is in accordance with democratic procedures. There are a lot of important elements here. And in fact, this article was hugely debated in the past few years when Hong Kong's started to debate how we reform our current system to choose our Chief Executive. I think there are a number of important elements here. Number one is ultimately we should have a chosen by universal suffrage, i.e., one man, one vote. This is the ultimate aim, which is expressly stated in the Basic Law. However, the Basic Law did say that there should be a gradual process, but it did not elaborate what do we mean by gradual, orderly. Some people argue that 1997 until now is now 24 years. It's already almost half of the 50 years of the guarantee period for Hong Kong. It's very gradual, and we are not seeing any progress. So that's one side of the argument. The other side of the argument is, yes, we tried. The government did actually try to put up a political reform in the 2016-2017 16? Yes. For the LegCo to pass the law to change the way we choose our chief executive. Unfortunately, the bill was not passed. The political reform package was voted down by our own LegCo. So that's why we are stuck with the very old method to the chief executive, which I'll come back to in a minute, chosen by a 1,200 strong selection committee or nomination committee. So the method for selecting the C is prescribed in Annex 1 of the Basic Law. Like I said, originally, after 1997, the method was chosen by a 600 strong selection committee. Now it's extended to 1,200. And this 1,200 selection committee members, they are also through other elections from public, from professional bodies. So it's sort of like a very indirect way to choose our chief executive, which is still far from our ultimate goal of having a universal suffrage. Which again, to me, I'm disappointed as a normal Hong Kong citizen that we still haven't actually reached the stage that we can actually have a universal suffrage, which is promised in the Basic Law. Legislative Council, the second branch of our government. Article 66 of the Basic Law says that the Legislative Council shall be our legislature. It is invested with the law-making powers. It's our law-making body. Article 23, important article as well, also a controversial one. This is to do with national security. Under Article 23 of the Basic Law, Hong Kong has an obligation. Why I say it's obligation? Because the word shall here. Hong Kong shall enact laws on its own to prohibit any act of 7 activities: treason, secession, sedition, subversion against central government, theft of state secrets, prohibition for foreign political bodies from conducting political activities in Hong Kong, prohibiting political organizations from establishing ties with foreign political bodies. So there are 7 requirements under the Article 23. For those who've followed the development of Hong Kong, the Hong Kong government did try to enact Article 23, fulfill its obligation back in 2003, 18 years ago. Unfortunately, the bill was proposed, creating a huge debate in the community. Some of the people are scared. They will say they are a bit worried that the law on treason, secession, sedition, state secrets, political affiliations would affect their freedoms, would adversely take away their freedom of speech, assembly, etc., etc. To get a long story short, after huge debate and a big demonstration in 2003, the government abolished the bill. They withdrew the bill to enact Article 23. To me, again, this is another disappointment because it's so clear that under Article 23 is Hong Kong's obligation to enact a law to prohibit this national security issues, which in a way led to the national security law being enacted last year, 2020, by Beijing and included in Annex 3 of the Basic Law. So what I'm trying to say that if under Article 23, our own legislature properly passed a law fulfilling our constitutional obligations, perhaps, I don't know, I'm just putting a big question mark out here, perhaps we did not have to have the national security law to be enacted by the central government, by the NPC, National People's Congress. It's just a big question mark. In any event, It's still an obligation under Article 23. It's still a constitutional obligation for Hong Kong to do that. Notwithstanding the national security law, we still have to do something about this 7 crimes to be outlawed. Let's turn our attention to some of the powers and functions of Hong Kong's Legislative Council, our Congress, our Parliament. It has the power to enact, amend, appeal laws, examine, approve budgets introduced by the government. We talked about that earlier. Approve taxation, public expenditure, receive, debate the chief executive policy addresses. Again, the chief executive she goes to the LegCo at least once a year to deliver the policy addresses on an annual basis, and then the LegCo will debate. Raise questions on the government work, debate any issue of public interest, endorse appointment of the Court of Final Appeal judges and Chief Judge of the High Court. Not all the judges, but the judges of the Court of Final Appeal, the highest court, the LegCo has power to endorse their appointment. And the Chief Judge of the High Court only, but not other judges. Remember, we talked about that earlier, that all the judges are to be appointed by the Chief Executive, but the LegCo, the Legislative Council, does have a role to play to endorse their appointment. Again, this is similar in other jurisdictions, for example, the US, slight similarity there. Number 8, to receive and handle complaints from Hong Kong residents. Number 9, if there's a motion jointly by 1/4 of the members, charges the chief executive with the breach of law, or if he or she refuses to resign, then the Legislative Council can pass a motion to investigate or to form a committee to investigate the chief executive. All in all, this is a bit like the impeachment procedure we are looking at in the US. Not exactly the same, but there's a similar procedure to impeach the chief executive. Again, coming back to my very early point, this is the check and balance between the executive branch, the legislative branch. Number 10, to summon the persons to testify to give evidence. So, like I said, some of the nature of the Hong Kong Legislative Council, the chief executive, are similar to some other Western styles democracy, whether it's a presidential system or parliamentary system country. There's some similarities here, but Hong Kong is unique, as I always emphasize. It's not an independent country. It's part of a bigger unitary country, China, as a special administrative region. So you cannot simply compare Hong Kong system to a Western democracies. It's completely inappropriate. But there are similarities in the sense that the 3 branches of the government does have check and balance on each other, which comes to the 3rd part of the branches of the government, the judiciary. Hong Kong has a very, very independent judiciary, and we cherish this arrangement. And as a lawyer, of course, I really appreciate the maintenance of the judicial independence. And the chief executive repeatedly reaffirmed the international community that Hong Kong's judicial independence will be maintained. Article 80 of the Basic Law, the courts of Hong Kong shall be the judiciary of Hong Kong, exercising judicial power. The important point is the 2nd paragraph here. Hong Kong adopts a separate, different common law legal system, which is different from the one in China. In other words, Hong Kong is the only city within the whole of China that practices common law. Because under the joint declaration we talked about yesterday, under the Basic Law, all the law previously in force before 1997 shall continue into the Hong Kong Special Administrative Region after the handover. The Judiciary, Article 81, important article. This is the picture of our former Chief Executive, Justice Ma, taken in 2020 in the ceremonial opening of legal year. And by the way, just earlier this week, Justice Ma stepped down as the Chief Executive, and we have just had a new Chief Justice, Justice Andrew Cheung, who has just taken office earlier this week, Monday, 11th of January, 2021. Article 81 provides that all the courts, including the Court of Final Appeal, the High Court, district courts, magistrates, and other courts, shall be established. So this is the provision establishing the judicial system here. Like I said earlier, the judicial system previously practiced in Hong Kong shall be maintained, except for those changes following the establishment of the Court of Final Appeal. I think I mentioned briefly yesterday, before the handover, before 1997, the highest Court of Appeal actually was the Privy Council of the House of Lords in the United Kingdom. And after 1997, we finally have our own Court of Final Appeal, which is a well-respected body internationally. Article 83, structure, powers, functions of the courts of Hong Kong shall be prescribed by law. Article 82, the power of final adjudication shall be vested in the Court of Final Appeal, like I said. This is important, the second limb of it, which may, as required, invite judges from other common law jurisdictions to sit on the Court of Final Appeal. Let me spend a few minutes on this Article 82. Hands on my heart, I did a bit of comparative law myself. I haven't seen any, I would say, countries in the world allowing their highest courts to include a foreigner, to include a judge from foreign jurisdiction. Bearing in mind, in a common law environment, if you are familiar with the common law concept, it's a judge-made law concept. The judge in a common law court can actually make law. So apart from the legislature that make law, the judges in the common law courtroom can actually overturn some of the concepts, can create new judicial concept from a jurisprudence point of view. So this is such a flexible and powerful position for common law judges. With this in mind, when the basic law was promulgated, central government actually agrees that, okay, Hong Kong is so unique because of its historic, because of its history. Let the Hong Kong highest court invite foreign judges to sit on the Court of Final Appeal. This is so, I would say, liberal from that angle, because that foreign judge can actually influence the system in Hong Kong. So what happens in practice is, in Hong Kong, the Court of Final Appeal, there are 5 judges. It's a bit like the Supreme Court in the US with 9 judges, but in our Court of Final Appeal, there are 5 judges with the Chief Justice, which must be a Hong Kong local permanent resident, a Chief Justice local. And then there are 3 permanent judges, Hong Kong judges, but the 5th one is always a foreign judge from other common law jurisdictions. UK, Australia, Canada, New Zealand. We haven't got anybody from the US, but all these common law jurisdictions, they did have someone sit on the panel of foreign judges. So there's a panel of non-permanent overseas judges. As I recall, there are 13 of them now. So every time there is a case for Court of Final Appeal to consider, they will invite one out of these 13 judges on the panel. The current panel made up of very prominent judges from the UK. In fact, the practice is always invite the current or the past chief justices from the UK, Supreme Court, or Australia or Canada. Usually they are very, very well-respected, international respected judges. So this is actually, to me, this is the most unique arrangement of our judicial system. And this is, again, to me, the most important safeguards of all. Foreign judges sitting on our court to make decisions. Later on, we will talk about freedoms and rights. There are express provision in the Basic Law protecting human rights. And these rights, these laws, will ultimately be looked at by a foreign judge. So to me, that's a very unique arrangement. Okay, let's move on. Judicial independence expressly protected under Article 85 of the Basic Law. The courts shall exercise judicial power independently, free from any interference. Members of the judiciary shall be immune from legal action in the performance of the judicial functions. Article 84, the courts shall adjudicate cases in accordance with the laws prescribed in Article 18 of this law and may refer to precedents and other common law jurisdictions. And again, this is important because Hong Kong's common law tradition, we looked at foreign other common law jurisdictions rationale and borrow them. They're not binding, they're not automatically binding in Hong Kong, but they can be borrowed in Hong Kong courts and vice versa. And in fact, it happened all the time after 1997. The decision made by the Hong Kong Court of Final Appeal, the cases, the rationale was actually referred to and adopted by other jurisdictions, by the UK courts, by the Australian courts. So that's actually shows you how high regard other people pay to Hong Kong judiciary after handover. Article 160, I mentioned that earlier. After the handover, laws previously enforced in Hong Kong shall be adopted by the Hong Kong Special Administrative Region, except for those expressly declared to be in contravention of this law. Otherwise, more or less, they will continue to be in existence. And the laws, of course, include statutes and also case laws. And I will now turn to talk a little bit about the rights, duties, and freedoms. They are all expressly protected under Chapter 3 of the Basic Law. Most of the rights protected under common law system and traditional rule of law concept, they are all enshrined in the Basic Law. For example, no one is above the law. These are all recognized by the Basic Law. It also the Basic Law also spells out the freedoms, limitations, duties, and obligations. More specifically, Article 25, all residents shall be equal before the law, including the government. Not only residents, but including the government shall obey the same set of law. Article 26, permanent residents has the right to vote and stand for election. Article 27, all these basic rights, freedom of speech, press, association, assembly, procession, demonstration, trade unions, strike are all protected expressly under Article 27. Article 28, freedom of person. Any Hong Kong citizens shall not be subject to unlawful arrest, detention, imprisonment, torture, or deprivation of life, etc., etc. Article 29, homes and other premises shall be inviolable, cannot be arbitrary or unlawfully searched, intruded, etc. Article 30, freedom and privacy of communications protected. Article 31, freedom of movement. Hong Kong citizens can freely move. Of course, slightly difficult with the pandemic in place. But after all, there's a freedom of movement here. Freedom of conscience, freedom of religious belief. Article 32. Article 33, choice of occupation. Article 34, freedom, academic freedom, cultural freedom. Article 35, confidential legal advice. Clients' privilege documents with their lawyers are protected expressly under the Basic Law. This is the important provision I just mentioned. The right to institute legal proceedings in the courts against the acts of the executive authorities and the personnel. What it means in practice is the system of judicial review, which again, I'll spend a little bit more time on this. Judicial review in Hong Kong is so commonly used that I remember there's a speech once, people said that Hong Kong's government maybe is the government being sued most often in the world. Maybe it's a joke, I don't know, I haven't done any statistics, but it's true that there are a growing number of cases against the government, against its executive decisions, against some of the laws, whether they are compatible with the basic rights protected under the Basic Law. So there's a judicial review system for common citizens to challenge the government. Hong Kong has its own Bill of Rights Ordinance as well. The ICCPR, the International Covenant on Civil and Political Rights, is expressly stated in the Bill of Rights Ordinance, alongside the Basic Law, which we looked at just a moment. Basically, it's a repeat of all the ICCPR protection. So, in other words, all the rights and freedoms enjoyed by Hong Kong citizens shall not be restricted unless as prescribed by law. I mentioned that all the basic rights and freedoms, liberty, security, no torture, blah, 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 all contained in the Bill of Rights, which again repeated in the Basic Law itself. Before I move on to the next topic, the reason I stress so much about this human rights and the unique judicial system is, to me, this is the best safeguards. On the one hand, you have written Bill of Rights Ordinance, you have the built-in protection under the Basic Law, and on the other hand, you have a very independent judiciary with the highest court can even invite foreign judges. So with that angle, all these rights are really protected instead of paying lip service. So that's why I cherish the current arrangement. I say this especially in recent years. There has been a lot of criticisms by different camps, different schools of thoughts. People always criticize the Hong Kong judges simply because they don't like the outcome of the judgment. But to me, all this built-in mechanism makes sure that you have the right to appeal if you are not satisfied with the judgment. And like I said, the Court of Final Appeal rests with the judges in Hong Kong. So the Hong Kong judges decide the case ultimately. Of course, in the next chapter, we will talk about the power of National People's Congress to interpret law. But leaving that aside for the time being, our judicial system is self-contained in that sense. And with all the rights expressly written for these well-known judges to consider. So I leave it to you to ponder whether that's a good enough protection. I think this is the last topic of today, I hope, because I've been talking for too long. But this is so important that I can't leave it out when I design this program. NPC interpretations. NPCSC stands for National People's Congress Standing Committee. It's the highest organ of central government of China. The National People's Congress is the highest organ. Everything derives from their power, even the establishment of the Hong Kong Special Administrative Region. So under the Basic Law, Article 64, bracket 4, this is the Constitution of China, not the Basic Law. China's Constitution, Article 64, bracket 4, provides that the NPCSC, the Standing Committee of the NPC, has the power to interpret laws. So this is nothing to do with Hong Kong. This is talking about the national arrangement. The NPCSC has power to interpret laws. Bearing in mind, China is not a common law country. It's a civil law country with the special socialist system in its characters. So it's again a unique system, China. The Standing Committee of NPC has power to interpret laws. So bear this in mind. I'll come back to this point later. Article 158 of our Basic Law of Hong Kong expressly say that the power of interpretation of this law, meaning Basic Law, shall be vested in the NPCSC. So this should be looked at when we talk about the judicial independence early on. Yes, the Hong Kong Court of Final Appeal has the final judicial power to interpret all laws, including the Basic Law. The Hong Kong Court of Final Appeal actually look at the Basic Law and interpret. But the final power of interpretation is actually with the NPCSC. Coming back to my very early point, saying that Hong Kong is such a hybrid, unique system. It's not an independent country. From a common law angle, the highest court is the highest court. But in Hong Kong, there's a NPCSC in Beijing, seemingly higher than the Hong Kong Court of Final Appeal. Seemingly, but when you look at it more closely, there are a lot of safeguards under 158, which I haven't actually typed it out here, which says that, yes, the NPCSC can interpret the law if, later on we can see one of the cases, if it thinks that the CFA misunderstands the Basic Law, which was enacted by NPC in the first place. But any interpretation will not affect the current case. So the CFA decided the case, that's the end of it. The NPCSC can make an interpretation, but not impacting on the current case. It will impact upon future cases. It will become a reference point for Hong Kong's Court of Final Appeal to look at in future. So that's another important safeguard under Article 158. Let's take a look at the interpretation by the NPCSC. I must admit, every time when the NPCSC makes an interpretation, it causes a lot of controversies. Reason being simple, because under a common law system, the court of final appeal is final. But every time when the NPCSC make an interpretation, people will say, hang on, what's the relationship? So to me, this is actually an important education process for not only Hong Kong people, for Hong Kong government, and also for the central government, how we actually deal with one country, two systems. This is such a unique, new, novel arrangement. Nobody has to deal with it. Let's look at the first time it was interpreted in 1999. I'm aware of the time, so I'm not going to talk about the background of the case a lot. But this case is called Ng Ling. It's a very, very important case in the development of Hong Kong judicial history. It's the first time the NPCSC made an interpretation. It's a case about right of abode. Put very simply, under the Basic Law, Article 24, I think, they said that lists out a number of criteria who has right of abode in Hong Kong. There's some dispute about the interpretation of that particular article under the Basic Law. The Court of Final Appeal decided that if you are born out of a marriage wedlock in China, even if one of your parents are not a Hong Kong citizen, the baby will still have right of abode in Hong Kong. In simple terms, this is all about this case. So when the judgment was handed down, the Hong Kong government was quite worried. They even estimated there are over 1 million young, newly born baby or future born babies in the mainland could be eligible, could achieve right of abode in Hong Kong, and could have a big impact on Hong Kong's resources. Anyway, there were a lot of debates whether that figure 1 million population or 1.6 even million population is over-exaggerated. Let's leaving that aside. The importance is it has a huge impact on people can come to Hong Kong and reside. After CFA made that ruling, the NPCSC actually clarified this was not the original intention of Article 24. It's actually set here about the right of abode. So in a way, I use the word overturn, maybe a slightly controversial word, but in any event, the interpretation say that no, this is not the case. But coming back to my earlier explanation, the interpretation did not impact upon the CFA ruling. So on that particular ruling, that in that case, the child did actually achieve right of abode in Hong Kong. It is only after the interpretation, the new law or the new concept applied. Second and third interpretation, 2004 and 5. I will talk about it in one go. Basically, the second and the third one is to do with the chief executive itself, the process to choose our chief executive. Again, there are some ambiguity for the method for selecting the chief executive and also the term of the chief executive. In simple terms, our first chief executive, Mr. Tung Chee-hwa, resigned before he finished his second term of 5 years. His term is 5 years. So he sort of resigned before the end of term. So the new chief executive, Sir Donald Tsang, Mr. Tsang took over the office, whether he took over the remaining term of Mr. Tung or started a new 5 years, something like that. But the important point is about the process. Who should initiate the process of interpretation under Article 158 of the Basic Law? So the interpretation is basically sought out some sort of a procedural matter, second time and the third time. The fourth time is actually the least controversial interpretation by the NPCSC. It's called the Congo case. It's to do with national immunity. In very simple terms, a company in Hong Kong, whether it should gain absolute state immunity or whether it's a qualified immunity. So in the end, the Hong Kong Court of Final Appeal say that, oh, this is too difficult for me. This is beyond my pay grade. Let's ask NPCSC. So the Court of Final Appeal voluntarily go to the Court of Final Appeal and ask for an interpretation. So this one, I would say, in 2011 is the least controversial. The last interpretation was happened 5 years ago in 2016. Is to do with the oath taking. There are a number of important points. What happened? The background was there were a number of legislative councillors after properly elected into the Legislative Council. And under the Basic Law, they are required to make an oath to sworn allegiance to the Basic Law, to the Hong Kong's Special Administrative Region. And the manner and the way they took their oath was controversial because they didn't actually willingly or unwillingly read out the whole oath. In the end, causes a lot of debate, and in the end, the NPCSC made an interpretation, and the key points are there. To uphold the basic law and to bear allegiance to the Hong Kong Special Administrative Region are the legal requirements. They are preconditions for standing any election in Hong Kong, for taking up any public offices. Number two of this interpretation, important one, oath taker must take the oath sincerely, solemnly. It's not a joke, it's not a game, it's not paying lip service. You must genuinely make the oath. Number three, if it is not properly, the oath was not properly taken, the oath taker can be disqualified. So these are the gist of this interpretation. I think the reason I spent more than 10 minutes on talking through these 5 interpretations is, again, just to show you how unique Hong Kong structure is. We have our common law system, common law judicial system. Then we have the NPCSC there to interpret the ultimate power to interpret the basic law. A very interesting mix of constitutional powers. We'd like also to touch on the concept of overall jurisdiction. This is actually a white paper issued by the State Council of China in 2014. Basically, it's a white paper listing out some of the issues by the State Council, the central government, powers being directly exercised by institutions of the central authorities, powers being granted by the NPC, the National People's Congress, to the Hong Kong government under the basic law, supervisory power, basically the power between the relationship between the central government and Hong Kong. I think all in all, what this document trying to say is to remind people of some of the provisions of the basic law. Because there was a trend that people say that, oh, Hong Kong, it's almost similar to an independent country. In fact, it's not. Of course, I always emphasize that Hong Kong is part of China under a very unique system with a high degree of autonomy. With all these benefits I mentioned yesterday, we don't pay taxes to the central government. We have our own police force. We have our own government. The central government will not plan their government policy for Hong Kong. Hong Kong's chief executive has his own policy address every year. I think the white paper, in a way, is to sort of remind Hong Kong citizens that, hey, by the way, there are a lot of power reserved by the central government. Some of them have not been exercised, but they're there. So to sum up what we've talked about in the past hour or so, we've talked about the 3 branches of the government in Hong Kong: executive, legislative, judicial, and the unique nature and the check and balance between the 3 of them, and also with the role of the central government above all, and the National People's Congress Standing Committee, their role. I also mentioned the chief executive is the head of the Hong Kong SAR, but it also has to be accountable to central government. The basic law and other local laws protect human rights. International Covenant on Civil and Political Rights is implemented in Hong Kong. The interpretation power of the basic law is ultimately vested in NPCSC, although Hong Kong courts are also authorized to interpret law using a common law angle. And finally, like I mentioned, the central government exercises overall jurisdiction over Hong Kong under express provisions in the basic law. I think that's all I want to talk about today, and I hope you find these information useful. I think the next session is now Q&A, opening up for questions. So from that angle, so thank you for your attention, and I turn the mic back to the Charmaine, our MC for tonight. Thank you. Charmaine?
Okay, thank you, Mr. Chen, for his enlightening seminar, which gave us a clear picture of how the one country, two systems policy operates. So in the next 30 minutes, we'll be holding a Q&A session. So if you have any questions on today's topics or anything you would like to discuss with our speaker, feel free to input it in the Q&A box at the bottom. You can raise your questions anonymously if you prefer not to disclose your identity. So all questions are welcome. So I just received our first question. Hi, CM, thank you for your seminar. I have a question on the fifth interpretation. Some people say that it was an amendment instead of an interpretation, as there were so many words added to the article. How should we distinguish or draw a line between an amendment and an interpretation? Why Article 159 was not adopted instead? Thank you. So may I have Mr. Chen to answer this question?
Thank you for the question. Very good question, in fact. How do we draw the line? Well, I must to start off, I myself is a common law trained lawyer. I'm more familiar with the common law arrangement. And like I said all the time, Hong Kong is such a novel, one country, two systems, such a novel thing. We are still in the process of try and error, believe it or not, after 1997, 24 years now. As I understand from the civil law country, apart from the judicial organ, the courts, the judges, there are a number of administrative bodies which can also issue regulations, also have legal impacts, legally binding rules, sub-rules, or interpretations, or guidance, how a particular piece of legislation is to be interpreted, is to be applicable. This is actually not uncommon in civil law jurisdiction for that sort of arrangement. So coming back to your question, the NPCSC is now interpreting a provision of the basic law. Why they not go through the other procedure, Article 159, which is actually to amend the basic law, to change the law, to change the constitution? Although I always mention basic law is not Hong Kong's constitution, it's a constitutional document. And the question is, if you want to change it, why do you not go through the proper procedure to change it? I think my simple answer is, it's the cultural difference here we're talking about. In China, as I always see the Supreme Court, the State Council, local governments, from time to time, they issue guidance, guidelines, or interpretations. It's actually very common under Chinese systems. So from their point of view, if there is a clarification to be made with regard to a particular provision under the Basic Law, they issue a clarification. We call it interpretation under 158. And that's the simple answer to your question. It's not that there's a need to change the Basic Law. It's just that the common law judges do not fully understand the original intention of the Basic Law, and that warrants a interpretation. So from their angle, it's not a change, it's not an amendment, but a clarification or interpretation. I hope that answers the first question. I think there are other questions as well. Charmaine, right?
Thank you, CM. We have another question on the Basic Law interpretations. So let me read it out. Out of the 5 NPCSC's interpretations of Basic Law, only one concerning diplomatic immunity in the Congo case was issued at the request of CFA. So do you think the other 4 interpretations have undermined the judicial independence of the Hong Kong court? CM, please.
Again, a very high standard question. When I explained the 5 times when the NPCSC interpreted the Basic Law, the 4th one about the Congo case is the least controversial, because the procedure is the court is from lower courts to Hong Kong, higher courts, then to the Hong Kong Court of Final Appeal, and the judges felt that it's out of their hands. They made the request to the NPCSC for interpretation. To me, that's a normal sort of appeal procedures from a common law point of view. So it's least controversial. That doesn't mean that the other 4 times are unlawful. They are also following a procedure which might not have been set out very clearly. And this is understandable. The Basic Law, always mentioned, is a constitutional document. Like other constitutions in other countries, they're usually not very long. Usually the Constitution set out the concept and let local laws to implement the details. Same things happen here in Hong Kong. The Basic Law is a very wide conceptual document. From time to time, we will face very difficult or different scenario that the Basic Law may not have stated clear enough to how to deal with it. The other 4 times exactly the same. The first time I told you about is right of abode. Second and third time is about the chief executive. The 5th time about oath taking. These are all new challenges faced by the Basic Law. Pausing here, let's look at the US, for example. The US Constitution was drafted first drafted in the 18th century. And many of the provisions are so outdated. There are so many updates, amendments. And even today, some of the challenges in the US Supreme Court, they still go back to the Founding Fathers. They look at what the Founding Fathers said more than 200 years ago in order to interpret the original intention of the US Constitution. Similar things actually happening here. We were trying to ascertain the original intention of our Basic Law, why this provision is put in place. So for the Hong Kong courts to voluntarily ask for interpretation is one way, but for the Hong Kong government to go out and ask for interpretation is also recognized as a lawful procedure. More importantly, even for the NPCSC, voluntarily to set out an interpretation is also a lawful process. So it's just a different way getting to the end. That's my answer. Next question, please.
Next question is, while Hong Kong adopts the common law system, Basic Law is written in a civil law manner. Would that be a problem for the Hong Kong courts if they were to interpret the Basic Law? Or have the courts ever attempted to interpret the law?
Very good question again. That's why I always said nobody ever said that one country, two systems is a piece of cake. It's easy. There's no precedence for you to refer to. The same goes to the Hong Kong judges. Hong Kong judges interpret Hong Kong local laws passed by the Legislative Council. Quite simple. At least it's a common law piece of legislation, so they're used to it. When you ask the Hong Kong courts to look at the Basic Law, which is a piece of legislation passed by the National People's Congress, it's a civil law. It's a civil law, piece of civil law. The same goes to the recent national security law. It's also passed by the National People's Congress. So you're actually asking a common law judge using Hong Kong tradition, common law tradition, to interpret the civil law, a piece of civil law jurisdiction, civil laws legislation. Hong Kong judges are so experienced; they've seen that and they've done that in the past 24 years with huge success. I actually saw no big problem for them to interpret a civil law piece of legislation. But I'm not saying that it's easy. There are a lot of technical difficulties, which I can talk about later in the day. For example, so-called the pepper and heart constitutional interpretation. How you look beyond a piece of legislation, the legislative intent of that legislation is a huge problem, a difficult one for Hong Kong judges, because you need to actually look at why that piece of legislation is passed by the National People's Congress, not by Hong Kong's own Legislative Council. So it's not easy, but it's doable. That's my answer. Next one, please.
The fourth question is, it seems to me that the Basic Law is in essence contradicting the Constitution of PRC. The Constitution of PRC stipulates that PRC is a socialist or communist country. How do we reconcile that?
This one is actually quite easy. It's actually specifically spelled out in the Basic Law. The Basic Law actually expressly, I think it's in Article 1 or 2. The socialist system in China does not apply to Hong Kong. As simple as that. That's the whole essence of one country, two systems. Hong Kong remain its own common law tradition, hugely influenced by the Western style democracies before 1997, albeit a colony. But China recognized all that, and that's why we have our Basic Law. Sort of like a Chinese war between Hong Kong and China, so that China's socialist system will not be applicable in Hong Kong. It's expressly stated in China's Constitution, Article 31, and also the Basic Law in Hong Kong. Next question.
One of the attendees asked CM, how would you comment when foreign government, especially European and US one, criticize that it is no longer one country, two system or autonomy as promised before 1997?
I think it's a fair question, and in fact, many media in the West, and indeed during the past week, I think the foreign ministers or foreign secretaries of a number of countries, they jointly issued a statement saying that the one country, two systems in Hong Kong is dead. The concept is no longer there. The high degree of autonomy in Hong Kong is now taken away. I disagree. To be honest, I disagree. The fact that the presentation I made yesterday, today, the system remained intact, basically. When I talk about judicial independence, the foreign judges element, the ICCPR, International Covenant on Civil and Political Rights, all the freedoms still protected. If your rights are being challenged, you can always take your case through the Hong Kong courts, which I always emphasize as independently deciding cases. Not to say that there are no, it's a very, like I say, it's an easy arrangement. We face challenges all the time, especially during 2019. There's a huge protest on the street, lack of Article 23 to protect national security, causing a lot of problems. And then we had the national security law enacted by National People's Congress last year, applicable in Hong Kong. All these are new challenges for Hong Kong. But all in all, I would strongly argue that the political legal system originally designed under the Basic Law remain intact. In the actual implementation level, of course, there are challenges, difficulties, but all in all, I would say I disagree that one country, two systems are no longer there, and we lost our high degree of the autonomy, and I don't agree with that. Thank you. Any other questions or comments, or even I welcome participants to disagree with me if you think that I'm too optimistic, or I said something wrong. I'm welcome to any comments.
An attendee asked, could one use basic law in the court as their argument? Maybe may I invite this attendee to elaborate a bit more about this question?
Sorry, what's the question again?
Could one use basic law in the court as their argument?
I'll try to answer. I don't fully understand the question, but I guess I've been talking about freedoms, talking about human rights, everything being protected under the Basic Law. I think as an attorney, if you are being charged with any criminal laws, any criminal offenses, including the national security law, if you come to me as a client and ask, hey, Mr. Chen, can you defend me? I'm being charged with this particular piece of offense. Of course, my duty as a lawyer will look at your charge, under which statute, under which provision are you being charged? Number two, are there any cases, any precedents to support the prosecution case? And then my argument will go through my, at least internally under my mental exercise for myself, whether this charge, this crime, is in accordance with the Basic Law. Will this piece of legislation contravene or take away your human rights expressly protected by the Basic Law? That would be one of my arguments in the courtroom. So in a roundabout way, I think my answer to your question is the Basic Law is a well-drafted document, and I truly believe if we stick to the Basic Law, all our human rights, all our basic rights will be protected. And like I said, there's even an article saying that in the ultimate aim, ultimate goal is for universal suffrage. We choose our chief executive and the legislature, one man, one vote. That's actually written in the Basic Law. So let's protect our Basic Law, cherish it even. That's my answer to it. And I think I've answered all the questions, I hope, for tonight. Have I, Charmaine?
Yes. If anyone have any questions or anything you'd like to discuss, or you may also input in the Q&A box in the next remaining 10 minutes.
Well, in fact, I would say that if there's no more questions, then perhaps we can call it a day. I think I hope it's useful, and all these questions are so valid and so relevant. And you'll keep coming back these questions in the coming years. And especially with the national security law being imposed last year. And I expect more people will try to argue that, whether the Hong Kong system is now changed. But I still have faith in our judicial system, at least. And I hope the political reform can happen in accordance with the basic law at some point, so that we have development in our system in selecting our chief executive and the legislative councillors. Okay, if there's no more question, then thank you for your attention. I think that's it for today. Thank you.
Okay, once again, thank you, Mr. Chen, for sharing his time and expertise with us tonight. And also thank you all for joining the seminar. So good night and have a nice weekend.